Council Medad, court has cited the gravity of the offence and concerns over state security as grounds for denying bail. Do you believe the Chief Magistrate probably exercised her discretion to deny your client, Erias Lukwago, bail?
I think the learned Chief Magistrate did not properly exercise her discretion in denying bail. We are beneficiaries of state security, but I know that this matter has not reached that stage of hearing to see who is right, who is wrong. But relying on the gravity of the offense charged to deny bail is absolutely improper. Because what that would do is that if the government wants you out of circulation, all they need is to make an allegation of a grave offense. And then you suffer irreparably, you get incarcerated for as long as the state wants. Because look at Dr. Besigye's case. I think now we are going into 2 years. They are out of circulation simply because the offense is grave. They are grave offenses by their nature. But we've seen other people granted bail, even with grave offenses. So I think the exercise of judicial discretion was improper, but I would not be party to disparaging a judicial officer. I can only say or air out my criticism or disagreement with respect and with immense respect.
Still in her ruling based on submissions from the prosecution, she argued that, prosecution argued that releasing Lukwago could interfere with ongoing investigations into an offense that carries a life sentence upon conviction. How do you respond to that concern?
Now, the question of interfering with witnesses equally does not arise much. One, because it is speculative. Two, because the alleged principal offenders, the treason suspects, have had their trial begin. Investigations have been concluded. Lukwago does not even know who those people accusing him or testifying against him are. So where is his ability to even interfere with them? The court has accepted by judicial acceptance that the man is unwell. So you are saying this sick man is going to be running around looking for these so-called witnesses or accusers to intimidate them? Most probably these are state agents, state operatives. So how does a prisoner, a civilian, interfere with these people's testimonies, if at all?
On a positive note, the ruling seems to agree with the health concerns of your client. Are you satisfied that court gave adequate weight to the health considerations in reaching its decision?
I think the judicial officer attached sufficient weight to the health concerns that we put before court, to be fair to her. I think she has also weighed the environment around, which equally carried sufficient weight. That's why she said, let him be referred to Mulago National Referral Hospital. The only thing that we need not to lose sight of is that Mulago has referred him before, has established and expressed inability to deal with his conditions. Actually, not condition, they are now conditions. Mulago cannot deal with them. And those documents are on record. The learned Chief Magistrate examined them and agreed that his concerns are neither frivolous nor speculative. They are real. they are real threats to his life. So, on that alone, I think she would have released, but she says that alone is not sufficient because we have no certification from Mulago that, from Luzira that they can't treat. Indeed, Luzira cannot treat if Mulago cannot treat. If Nakasero could not treat those conditions, and they referred. In the medical profession, it is allowed and it is common to make referrals. Otherwise, even government officers would not be receiving treatment abroad. I know of so many senior government officers who have been outside for treatment. So referral is acceptable. Mulago referred this patient by a decision of the National Medical Board. The Medical Board of Uganda said he cannot be treated here. We have not reached the science of treating this condition, because these conditions we are talking about.
Thank you so much, Councilman Lubega Segona, for your time and for allowing to speak to NTV.